Welcome to Red, White, and Blue. I'm Gary Polland from the right.
And he insists on being from somewhere, and so I'll be David Jones from the left.
I think that's where you belong. This week on Red, White, and Blue, Harvey and its impact in the criminal justice system. And we have three really interesting guests, and we're fortunate to be here because their jobs have become much more complicated because of Harvey. First, Judge Paula Goodhart, who is our presiding judge of our county criminal courts. Secondly, Tucker Graves, who's president of the Harris County Criminal Lawyers Association. And finally, a show's old friend who's been on a number of times, Kim Ogg, who's Harris County District Attorney. Welcome to all three of you.
Yeah, in the interest of full disclosure, I think Gary and I both have to tell you all that we were both instrumental, I think it's fair to say, in getting Lee Rosenthal a federal bench.
Yeah, we did.
We did, right.
And
Should that come up?
It shouldn't. Right. yeah, and I'm sure we'll be talking about bail bonds at some point.
Yeah, right. So I saw this Tribune article that says that y'all lost 40 courtrooms. I think it's cells for 900 inmates were destroyed. That's what the Tribune said. Jury assembly room was destroyed. You have hundreds of trials that have been delayed, awaiting trial, including misdemeanors, where Murray Newman said it's a gross injustice to have a misdemeanant sitting in jail any longer than, well, of course, the code says 180 days, I think, if the state's not ready, and you're not ready, so they need to be out.
There's a question somewhere.
The DA is now spread over.
We've got a judge here. I'm going to object.
9 different locations. So I want to know, starting with you, Judge, how did you react with you as a public official when this horrible thing ended and you had to go into action and figure out how to manage a docket? You had to manage a docket? You had to. Let's hear how you did it.
So actually our action started before the storm hit. We anticipated that there was going to be a huge water event, and so court administration looked at the situation and looked at the weather reports, and we were proactive about deciding whether or not to hold courts in the misdemeanor courts the week of the storm. And so we canceled courts early. We tried to get that message out as soon as we could to all the stakeholders, to the DAs and to the defense bar and to obviously everyone involved in the court system. And so we did that pretty early on. And then once the storm hit, we continued communicating about court closures, but we did not suspend jail dockets. So for example, for the individuals who were in jail pre-trial, so they had pending cases, we lost only 1 day of addressing those issues because of the storm. So we created a courtroom over at 49 San Jacinto, which is a jail facility, and the DAs stepped up and they were there, and defense attorneys stepped up and they were there, and we actually held court for individuals that were in jail on misdemeanor cases. So this notion of folks being detained for an excessive amount of time because of the storm is not accurate, because we literally lost 1 day of their cases being addressed because of the storm. And we continued those jail dockets for the next several weeks. They continued until today. I mean, we still continue those jail dockets. And then 2 weeks after the storm hit, we were able to reopen courts for those folks who had cases pending who were not in jail and they were on bond.
So how did the defense bar react to this shifting of resources in courtrooms and jail dockets and bond dockets, and how'd you react?
Well, there was a lot of confusion at first. I mean, we were getting good information from the judge and from the district attorney's office, but when you have 700 members of Harris County criminal lawyers, it's like herding cats. They keep hearing rumors and innuendo and things going on, and they're asking around. The biggest problem we faced was communicating with our clients. They were very confused. The ones that were out on bond, they did not know what to do, where to go. And that, in the first 2 weeks, that was the biggest problem we faced, was dealing with our clients, assuring them that the judges were not revoking bonds, that we were in a state of chaos, and that we were going to get this thing worked out, and we would be able to tell you when the next time for you to go to court.
And Ms. Ogg, were you involved in any of this? Why did you get spread out over 9 different locations?
Yes, I was involved in all of it throughout the storm and after the storm. And our biggest challenge was getting people and files to the right places in the courthouse complex, because the dockets were no longer being held in the traditional courtrooms. Instead, they were being held in the jails. And I think because of bail reform and Judge Rosenthal's order that misdemeanor defendants are released generally now after 24 hours. There was not an overload in the misdemeanor courts.
That couldn't have happened at a better time.
I was going to say,
Yeah, really.
But in the federal, I mean, in the felony courts, I think there's no question that absent trials, we've seen an increase in the population in the jail, and that those are a priority to get tried and to get disposed. And so we worked through looking at felony cases to see what we could dispose of with dismissals, with back time pleas, and we dismissed about 110 drug cases in the first week. Again, in the interest of justice and trying to get the jail, keep the jail in a position where they could receive the defendants then that were being arrested each night.
Gary, I don't know whether you have any pending cases, but the word is out that the district attorney is giving them away.
Yeah, well, I have a huge docket, as you know, David. But my question for the district attorney, David mentioned your offices are spread out over 9 or 10 buildings because you had to find space for your office. But the disruption that took place, because, at least in my opinion, and I think many others, this building, the Criminal Justice Center, is just dysfunctional.
Well, I'm not about to defend the Criminal
Good.
Justice Center.
So-
I would be happy to prosecute the Criminal Justice Center if it were a person.
Well, you might, maybe, I don't know. Maybe there was a
That building
crime
was
occurred.
obsolete the day it was opened. I'm just telling you, it was obsolete. It was designed poorly, but
And you think it should be leveled?
I think it should be completely level. I spoke to Commissioner's Court on that last week. We actually got a response. We thought we might just be blowing in the wind on this, but Office of Management and Budget have asked to meet with us and kind of go over our proposals. So
there's a
maybe
possibility.
There's a
In fact,
possibility.
one of the ideas that's been mentioned is the building should be retrofitted as an office building, which is really what the design is for. And then one of the ideas that actually you came up with, Judge, was that we could take the Family Law Center and remodel it by floors and put the county criminal courts in there. But you could do it and still use it, and then you could build a new center for the felony courts. And actually, the DAs could take over much more space in an office building, as long as they come up with a way to prevent future flooding. But this building, I mean, how many millions and millions have we spent? Well, now it would be twice if we fix it for a building that is just not functional. And of course, your office has got to be in chaos.
Let me
My
say,
goodness.
I would support, there's a lot of room for improvement in future plans, and I would support all of them. The problems that it caused our individual prosecutors were innumerable. A lot of people were flooded. Others couldn't get downtown. We had to meet our obligations and represent the state of Texas at the jail dockets. And so we had people who worked through the storm 6 days in a row, no breaks, no nothing. They were real soldiers, and I'm very proud of them.
I think that was on both sides. The judges were
That's
down
true.
there, defense lawyers were
Yep.
down there trying to move the docket and make sure that these individuals were having their rights protected.
I was not down there.
I think it wouldn't have worked. We would not have been up and running in the short amount of time that we were, had it not been for the efforts of everybody involved. I mean, you
agree.
just saw people who they had a job to do, and they stepped up and they did their job and they did it well.
And your information that you gave out to lawyers along the way, the updates that I got and ignored but read, were excellent. I mean, excellent. If I'd have been a practicing lawyer at the time, I would.
The judge was communicating with Harris County criminal lawyers, and immediately when she would tell me something, it would go out to all the membership. So the communication, and Kim would do the same thing. So we had a kind of a three-way conversation going among us about what was going on and how we were going to move forward.
Yeah, in
So,
fact,
go ahead.
My comment was going to say that if you talked about this story, if we were here in July, talking about major flooding event like we ended up having, and what would have been the reaction of the system? Most people would have guessed that the criminal justice system would have been crippled for months.
So let me-
it's really a credit to all of you for the hard work that you and the people you work with did to do this. It's just really amazing.
I may vote to reelect all of you.
It was the largest
hold you to that.
natural disaster in the history of the country. And so I think Houstonians have a lot to be proud of. Law and order prevailed on the street,
Yes.
in the courts. It is delayed, and some say justice delayed is no justice, and I think everybody's working toward remedying that. We want more trials. We want them faster. These are things that I've been talking with the judges about, appearing in front of the different, both sets of county court judges and district court judges, to talk about some proposed changes in the docket system. But I would say that all in all, it's just as Judge Goodhart said, people stepped up.
Well, one of you mentioned, Roosevelt Judge, that ordered this major, kind of reform of bail system on misdemeanor cases, which is now up to the Fifth Circuit. And I just want to know whether or not any of you think that it is being followed, her order, and how hard is it to do so, given the complications that we all know you have.
Well, her order is actually directed to the sheriff of the county because she ordered that the sheriff would basically be the person to decide whether somebody was going to get released or not based on some factors that she set out. But I want to point out that before the lawsuit was filed, in fact, much before that time, as far back as February of 2016, the judges met, and on both sides, misdemeanor judges and felony judges met with an expert who was introducing this idea to the Board of Judges about having a risk assessment release system in Harris County. Because studies had been done all across the United States that suggested that the best way to determine how somebody should be released is not determined by the charge that they are facing, but their individual risk level. And the judges embraced that idea, and we said, yeah, that makes sense. It makes sense that when you decide how to set somebody's bail, that it is based on their risk level. Are they a risk to go out and hurt somebody again? Are they a risk to go out and reoffend? Are they a risk at not coming back to court? And so we embraced that idea, and we started working towards adopting this risk assessment in Harris County.
This was pre-Rosenthal.
This is pre-Rosenthal. This is pre-lawsuit. And so the Coordinating Council, the Criminal Justice Coordinating Council, which is a group made up of stakeholders of criminal justice from all facets of criminal justice, came together, and they were working on this through a MacArthur Foundation grant. And so as we were working towards implementing that in Harris County, that's when the lawsuit was filed. And so the judge's ruling came at a time when we were already working towards bail reform in Harris County, and that was a bipartisan, collaborative effort amongst all stakeholders at the time in Harris County.
Well, I have a different question about the bail bond program. Actually, a couple. Is it working, or is there any concerns that any of you might have about how Judge Rosenthal's order has been implemented?
Well, in other words, you have to talk to the sheriff on that.
I think we have different, we around this table have different,
And I'm interested in
have
this
different
piece.
views on it. But it is a federal court order, and so it is being followed.
No, I recognize that.
And that was a
Is it
question,
working?
is it being followed? Is it working? Mostly, but not entirely. There are concerns that I have about the risk that certain offenders who are only charged with misdemeanors present to the community. I believe that those concerns about public safety are best addressed through conditions of bail at the misdemeanor level. Felony is a different subject.
Well, I'd agree with Kim that there are certain, even misdemeanors, particularly you see on the family violence. I think we're in agreement that those type situations need to be evaluated and not let somebody out that's going to go right back and do it again.
That would be
So
scary.
here's my concern, though. The way that what we have seen and what we've observed after the order was implemented is that if an individual, let's say, for example, somebody's charged with DWI as a second offender, and their first DWI was just a year ago. That is a Class A misdemeanor. That is the type of case that is a misdemeanor. It's not a low-level misdemeanor like a traffic ticket. It's very serious, particularly considering what our alcohol fatality rate is in Harris County. And so if somebody in that situation comes to court and the judge puts conditions of bond on them, so rules that they have to follow while they're out on bond and they're not in jail, their expectation is that they're going to follow them. And it's really a matter of public safety. You order them to put an interlock device on their car to monitor whether they're consuming alcohol before they try to start their car. That's actually mandated by law that we do that on a DWI second.
Well,
let's
is
say
that the sheriff
individual-
recognizing that you have that authority? And
It's the
giving
magistrates that have to put the conditions
the
on, because
magistrates or
before
the
these
judges.
judges see
I see,
them,
I see.
they go before a magistrate. And so we've had trouble getting conditions of bail through magistrate presentations at what we call a 1715 hearing.
15, 17.
Again, something out of the code. Yes. And so these probable cause hearings are where the magistrates are asked by the state, by our lawyers, to put conditions on bail.
Such as what
Such
Judge Goodhart
as
is
the
talking
interlock.
about?
And
That's what happens is, so if the judge
But
or
they
the
don't
magistrate,
always.
they don't always, and so then they come in front
a
of
problem.
the county court judge, and we assess those conditions, and then the expectation is that they're going to follow those conditions. Well, under the order, if the individual does not comply, so they just say, nope, I'm going to keep driving, I'm going to keep drinking, and I'm not going to have that device on my car, and the judge says, well, then the consequence is I'm going to revoke your bond and put you back in jail. Once they're rearrested because they're failing to follow the court order, if they say, well, I can't afford the bond, the sheriff will release them. And that is a continuing, cycling process. They can get arrested for not doing what they're asked to do, which is to put an interlock on their car, and then they're released and they still don't comply. They're arrested and they're released, and it just is a revolving
And that's
door.
And
why-
I think that part of the order should be considered should be
Modification.
reconsidered for
Well,
modification. And
that's
I
a
think that is
hypothetical.
in the works.
Well, that's the
And
problem with
that's-
the order. There's one
but
size
the-
fits all.
but
What
the
do you got?
reason-
What do you got
but
against
the-
hypotheticals?
Well, I've got a lot against hypothetical, but you know, I guess
that's fact.
I know, but I mean, it could happen. I
Yeah.
understand all that, but I guess we've only been under it for about 2 months now. Is that right?
No, no.
And under Rosenthal's order.
Right. No, it's been longer than that.
What?
Yeah.
And I mean, but I mean, do we have any numbers showing exactly what, what you're talking about? How many times has it happened?
Well,
I bet the position of everyone at this table should be, if it happened once, it's too many times.
Right.
Because the risk factors need to be incorporated, and you should not be rewarded for disobedience for the court. I mean, that should not be put up
You
with.
shouldn't. That's right. The problem is when the numbers that come before Judge Goodhart and the other judges are huge. About 60,000 misdemeanors a year. Things are going to happen when people are awaiting trial. But what we are avoiding is so much worse. So yes, things can happen. People can violate the conditions of their bail. They might not get any conditions of bail, which I think is dangerous. And so we know, because it's a numbers game, that some bad things will happen.
And that was happening beforehand.
It
anyway.
was on cash bonds or on surety bonds. It was still happening. But what we're avoiding now are keeping people who simply cannot afford to get out. That being the big criteria that in fact before kept them in. They just couldn't afford the bond, whether it was $500 or whether it was $5,000. And because of that, they would stay in jail, and then the pressure would mount for them to plead guilty. Not necessarily because they were guilty, but so that they could get out, so that they could return to work, get the kids, get the car out of the impound. That's the wrong reason for people to plead guilty, and
But-
we don't want them to plead guilty
and,
for
and
that
I
reason.
think that, and based on what I've heard, it sounds like that's what you all were working on before Judge Rosenthal and the lawsuit got in the way of your progress. So, be that as it may,
I don't
federal judge-
believe she got in the I don't believe
Well, she was
that she got in
invited.
the way of progress.
Well,
I
no,
think
she got invited to the party. But here's the problem. When we come back to the problem, and I'm sure you agree, that the situation that Judge Goodhart has described is not to be tolerated. That if people violate their bond rules and they're on a free bond, they don't get out again. They should not get out again.
Well,
Those rules are there
file your
designed-
amicus with the judge.
Yeah. Well, I'm
Okay.
actually see her in a couple of weeks, but I don't think she cares about
So
my
let me just
opinion on this one.
tell you
And
all
just a
where
point
you
of clarification, the order was June the 6th.
June the 6th.
It's
Let me
June.
just tell you all where your standing is in the United States in terms of bail reform. Okay, it has already happened. Major bail reform of
In
the
New
type
Jersey.
that you're looking at in Colorado, Illinois, Kentucky, New Jersey, with the support of Chris Christie, Illinois, Oregon, Nevada, Vermont, Hawaii. D.C., of course, eliminated money bail a long time ago. 29 cities, including
crime rate.
Chicago and Charlotte, have done away with money bail. 50 cities
Well,
in
they-
Alabama no longer allow inability to pay to keep people in jail. We have, of course, an Article 1715 that says that bail is not to be used to make it an instrument of oppression.
It also says that you are to consider 4 other factors when determining what somebody's bail should be, including the instant offense, so the circumstances of the crime itself. The bail should be sufficiently high enough to ensure that somebody's going to return to jail, and you also have to consider where the person's going to go out and reoffend and be a danger to the community. There are actually 5 factors for the judges to consider, along with ability to pay, not just one factor.
Family
And
history, education.
that's
But
right.
we are
And
talking
so-
misdemeanors. So there are several misdemeanors that present a greater threat than
Sure.
all the rest. Domestic
Absolutely.
violence, DWI, burglary of a motor vehicle,
Which used to be a felony.
which used to be a felony,
Terroristic
and
threat.
indecent exposure, which is not just a nuisance,
Unless you had to go to the bathroom. You know.
It's a charge, unfortunately, that's levied against a lot of homeless people
It
out
is
on the
because
street.
they know where to go to the bathroom.
But there's a difference between somebody who's actually exposing themselves
Right.
for their prurient interest as opposed to somebody who is using.
Well, I was going to
The
mention
bathroom
that,
outside.
I mean, you all know the juvenile system, which I'm quite familiar with. We have a risk-based assessment.
You do.
Everyone who comes into and it's free bond. There's no bail bond.
Right.
You get released or you're detained, and you get a hearing every 10 days.
Same as in the federal system.
Right, and there's a review of every young person who comes into the system. They're evaluated for risk and what their offense is. And then the determination is made whether they get released or not. And of course, if you know, there's a way you can keep asking every 10 days to get them released. But what the key is there is this risk assessment tool. It's done when the magistrate is reviewing the kids. They already have a report. They have a background
It's
report.
Well, that's what
done
we're doing
right
now.
now
Yeah, that's-
when
I
the
mean, that's-
magistrates see it. That's the problem that I have with them not assessing conditions of bail, and some of the magistrates just aren't doing it.
They'll replace them.
And
When
so-
she says magistrate, she's talking about the
Hearing
the
officers.
hearing
Hearing
officers, not
officers,
the
right,
county
the
criminal
judges.
court.
Well,
That's
here's
right.
here's
That
what
is
here's what I learned whenever
They
I
clean it up in the morning. When the defendants come back
Look, if
in
you're
front
not happy
of the
with the magistrates, get rid of
criminal
them.
court. But the problem is if there's a delay
Yeah.
between the magistrate hearing
Oh,
and the
yeah.
first
You
appearance,
can
and
lose
it's a
your
domestic
job.
violence.
Oh, well, that's, yeah.
It's a domestic violence
Danger.
case, and no MOAP or motion for protective order was filed. That is a threat to the community, and so I have a problem with
Absolutely.
that. And the bail lobby here is so strong in Texas that bail is a condition. It is a constitutional right in Texas, and so the ultimate fix, while the federal courts are involved, the ultimate fix I think is going to have to be legislative and constitutional.
Well, I did not read 192 pages of the Rosenthal opinion, but I did read what it was based on for the most part, and that was Roberson versus Richardson, Neil Richardson, a county court judge, 1987, an agreed judgment where all parties agreed that there would be the rights and privileges of all inmates are going to be respected, a right to prompt, fair, and reliable probable cause would be heard, a meaningful review of alternatives to pre-scheduled bail amounts would be heard, proof taken on same, and prompt appointment of counsel would be made. And after and he mentions all of the factors that you talk about, Judge, and as far as assessing.
It includes ties to the community as well.
And it did. But he wanted to make sure, it was mentioned within the opinion many times, that alternatives that there could be personal bonds with conditions were part of the deal, and that they should be looked at rather than money bail.
I think that
And I would say to you that if you read that opinion, you would say, we haven't been following the law for a quarter century.
I think you could add Harris County to your list there of locations that have been working on bail reform, because we were working on reforming the way that we evaluated bail in Harris County before the lawsuit, and we continue to do that to this day. That the Arnold tool, which assesses somebody's risk to not appear in court or to reoffend or to commit a new violent crime, was implemented at the beginning of August, and so that determines somebody's risk level. That Roberson order was the impetus to what was called a bail schedule that began back in the 80s, and that's when the magistrates came into play, and they are that first point of contact that when somebody's arrested, after the DA's office screens the charges and determines there's sufficient evidence for the individual to be charged, they're then placed under arrest and charged, and they go in front of a magistrate. That is that point when they have first contact with the hearing officer. And now, this summer, what we agreed to do and supported it was that each individual at that point has the opportunity to be represented by counsel with
But
the public
here's what
defender's
happens
office.
is what I'm understanding is that the hearing officers are saying, based on your priors, you don't get it. Safety, or making note, safety, you don't get it. When the Judge DeAnda in 1987 says that he wanted information sufficient to determine the accused eligibility for personal bond or alternatives to the bond schedule be a part of the hearing officer's duty. And what we learned from reading in the newspapers is that
Because everything in the
hearing
newspaper is
officers,
true.
hearing officers aren't.
It wasn't happening. Personal bonds on a large scale basis were not happening.
And that's been the way for years.
It has been that way for 25
Well, I
years.
want to, before we beat the bail bond to death, and we don't have much time left. We're under a minute.
Get to something that people
well,
care
no,
about.
I wanted to give you, Kim, a brief opportunity to comment on the community action plans that your transition team came
Thank
up
you.
with. Specifically, just say, what do you think the most important thing that came
You
up
got 30
with?
seconds.
I think it's important to listen to taxpayers who are experts on subject matter about what the problems are and what we should do about them. So I invited a lot of experts to sit on committees, along with activists, lawyers, judges, and they came up with recommendations about how to handle some thorny issues that are
And
facing
of course,
prosecutors.
the best
And
sentence,
then we
the
gave a
best sentence
community
about
action
the,
plan.
the best sentence in the Chronicle about that, it was that this was broadly laid out, and so we expect details.
We'll probably have to do a show
Details
just on
to
this.
follow. Thank you all for being here.
Check the website,
Yeah.
David. It's all there.
See us
all
next week
45 pages of it.
on Red, White, and Blue.